everyone. Thank you again for joining us today. Today, we'll be dealing with breach of contracts that come in many different flavors. We'll go through each of them in more detail. The purpose of today's webinar is educational. Today's presenter is yours truly. My name is Charles Miller. I'm a senior associate here at Achkar Law. Very excited to be leading today's webinar. I'm here representing Achkar Law. We are a litigation experienced firm focused on resolving these types of disputes as they come up, helping to navigate them, avoid them, and we serve all across Canada. The purpose of today's webinar, as I said, is educational. We're going to talk about what a breach of contract means, the types of breaches you come across, talk about practical steps to avoid these types of breaches as well as other contract disputes, and should one occur, we'll talk about the legal options for resolving them effectively and a way for you to turn your mind to this type of solution. What is a breach of contract? The very simple definition is a breach of contract occurs when one party fails to fulfill their obligations as outlined in the agreement. Full stop. Now, you might be thinking, hey, for such a simple definition, why does so much trouble seem to arise? Well, that's just with the nature of contracts, the nature of people. Even the simplest things can spell all sorts of trouble. You see, a lot of contract breaches occur just based on people misunderstanding the contract, how it's defined, the people and personnel involved. We'll get into more detail, but a lot of it comes down to meeting of the minds and just a misunderstanding of what's expected or mistakes occurring. There are also many types of contract breaches. There's the big ones, the material breach of contracts. These where a substantial failure has impacted a critical aspect of the contract. Typically, when a material breach occurs, everyone sees it. This is something that is quite a prima facie case, as you will, or just bold on the face of it. This breach occurred, such as a failure to pay, failure to deliver, something like that. Typically, it means that the contract is now done for. There's also minor breaches. These occur when just a partial failure occurs, such as a delayed payment or a misunderstanding of a term. These partial failures can usually be ironed out very quickly with a phone call, and usually a minor breach is just a quick resolution, doesn't involve avoiding or active litigation, something that can be resolved pretty quickly. Why do breaches occur? Again, as I mentioned before, it seems to be a very simple term, just a failure to deliver a certain aspect or misunderstanding of the agreement. Why do they occur? Well, first one, as I said, a misunderstanding of the contract terms. Every contract has three critical elements, but also a fourth element that many people forget. In every contract, there is an offer for services, an acceptance of those services, and some sort of consideration for this exchange. So I offer to build you a house, you accept this building, and in exchange for that, you'll pay me X amount of dollars. Those are the three critical terms of a contract, but there's also this fourth element called the meeting of the minds. This is critical in terms of everyone understands what they're agreeing to. In principle, you might understand what contract you're agreeing to, but the meeting of the minds almost has to be present in every aspect of a contract. So understanding when a deliverable is, when a deadline is, how much is going to be paid, when it's going to be paid, what the product will be. We can even talk about employment agreements as a contract. So what are the terms and duties of that role? So if you don't have a meeting of the minds for a contract, even if you think you both are on the same page, a breach might occur as somebody fails to fulfill the terms as you understood it. Another common breach is failing to meet a deadline or a deliverable. This is something that occurs, unfortunately, fairly frequently, or hopefully infrequently, depending on the industry. But if you have a deadline for delivering a service and someone doesn't meet it, that's a breach. Or if there'll be some financial or operational challenges that you might see are such that they due to like a pay cycle, you miss a payment. Or if, especially for operational, if you have logistical issues with trying to transport goods from one location to another, you might have some obstacles there. These types of breaches, I'm certain no one intends them, but they can occur in these types of contract disputes, especially at the commercial level. Some real world examples, terms types, missed deadlines in a service agreement. These happen frequently, especially in construction and renovation, where you are trying to deliver a certain good, but you're waiting on a supplier or waiting on a subcontractor to finish something, and then you miss a deadline because something got in the way. We also might see something here called force majeure, which is a fancy Latin for an act of God, delaying the delivery of something, such as a typhoon gets in the way of a boat delivering certain goods, or some other sort of frustration of contract. Missing this deadline is something that does occur in the real world. Another one is the non-payment in a vendor agreement. I mentioned before that sometimes pay cycles can interfere with paying your vendors. No one really intends not to pay their vendors, but depending on how the pay cycle works, you might not be able to meet that deadline, and that could cause a breach. Technically, missing that deadline is a breach. Whether or not it is a material breach or a minor breach depends on how the contract's drafted. Typically, though, a delayed payment is not considered so substantial, but it depends. If it's a very important part, it could be a material breach. Some other real world examples is ambiguous terms in partnership agreements. Now, I had partnership agreement put in there because when we talk about contracts, we're not just talking about your vendor agreements, your solicitor agreements, even your employment agreements. There's also the partnership agreements. Anytime two like-minded and brilliant individuals get together to form a partnership and create a business, good things arise usually. But if you don't have that meeting of the minds we talked about, the different personalities can get in the way. So if you have a partnership agreement that in principle seems to cover something quite clearly, but there's any ambiguous term that you interpret one way and your partner interprets a different way, then when that matter comes to the fore, you can end up with a major partnership dispute. Maybe the partnership will start to flounder. Maybe you guys should have sorted that out before you even signed the dotted line. But ambiguous terms in a partnership agreement is definitely something that can occur. When you're considering a contract breach coming and when you're drafting your contracts, there's a few key areas to watch, or a few key areas that, as a lawyer advising you, we would be advising you to look out for, keep your finger on. First one is unclear terms. So whenever you draft a contract, if there's any ambiguous language, it could lead to interpretation. Meeting of the minds, even in the moment, might be critical. But what if down the line our interpretation of the contract changes? If there's any ambiguous terms that could change meaning as time develops, well, now we have some unclear terms that could cause problems. So it's important to make sure that there's no unclear terms. Another one is deadlines and deliverables. Missing milestones and payment schedules especially often lead to disputes. So when you're thinking about putting a deadline or deliverable in your contract, make sure you're considering the full scope of your industry. You don't want to put a deadline in there that's too difficult to meet, and you don't want to put a deadline in there that's not considering other logistical issues you might have, such as if you're a contractor waiting for a subcontractor to finish a product, you might want to have it baked into your sheet that the deadlines do impact each other and work together. Deliverables be another one too, because as many vendor employers know, sometimes you do things exactly as your client demands, and then the second you send out the product, they say, whoa, 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 that's not what I ordered. Making sure it's clear what the deliverables are is very crucial. And communication gaps are also a very critical point. We're going to get more into communication gaps later on, but as every psychologist or couples counselor will tell you, communication is the key to every healthy relationship, and the same is said for business relationships and contracts. Making sure that you have a healthy relationship with your clients, with your employees, and with your partners is extremely important. Keep that key communication open, because if you don't, well, misunderstandings can arise, as well as failing to notify when something urgent comes up. What are some preventative steps you can take as a business owner to avoid these contract disputes? I want to emphasize a heavy caveat. You can do everything perfectly and still end up with a dispute. That's just the nature of doing business. It's just the nature of working with people. The advice we give today and the suggestions we give today really focus on what you can do to be as preventative as possible. But keep in mind that nothing's perfect. The first thing as a preventative step as a business to do a contract dispute is draft with precision. You've heard me say that ambiguous terms are a problem over and over again. You've heard me talk about meeting of the minds. That's why drafting with precision is so critical. Making sure that the roles, if you have for an employee, is clear. Making sure the timelines are clear, deliverables are clear, there's no ambiguous language. Make sure that there's no room for confusion and that it's clear that you do have a meeting of the minds when you're talking about what this contract is going to deliver. We also recommend reviewing these regularly. The law changes all the time. Last year, there were major changes in employment law. So then, as a business owner, your employment contracts need to be updated. That's not to mention how contract law evolves and adapts, how your commercial situations might evolve and adapt, how even your industry may evolve. So keeping your finger to the pulse is critical. Review your contracts regularly, make sure they're up to date, and make sure that everybody completely understands what you're agreeing to and it remains the same, or it changes accordingly with everybody on board. And to do this, the last thing we recommend is encouraging open communication. We know that a lot of businesses run by a handshake deal. That's just the way businesses are. As much as us lawyers try to tell you to keep everything in writing, make sure it's clear, do an email, don't do a phone call. The reality is that you're business owners. Businesses run with people. It's a phone call. It's a handshake. It's an understanding. That's true. And for our sakes as your lawyers, please do keep as much in writing. But if you are going to be talking to people, then lean into that strength of keeping that talking open, regular, foster a collaborative environment, address potential issues early. Litigation can sometimes be started and finished with a phone call and just an understanding between the parties. If you've got a good relationship with somebody, sometimes these material breaches in a contract can be minor ones that are resolved very quickly. What happens if a breach occurs? Again, you've done everything you could. You've tried to resolve it, but what are some options available to you if you have a breach, both material or minor? Well, there are 4 general options available to you. The first one is negotiations. This is what I was talking about before. You just have a direct discussion with somebody. Sometimes you may consider having your lawyer involved. That can sometimes help so that people are always just speaking very professionally. Passions can definitely get away from us when we care about our product and care about what we do. But negotiations are non-confrontational usually. They're just a matter of the parties coming together to try to seek a resolution. If you've attended this series before, you've probably heard me talk about how in business and commercial litigation, often when a problem arises, the other person has a solution in mind. You may have a solution in mind, and sometimes just negotiating with them will get to it. Now, negotiation works if you're kind of speaking the same language and everyone sees things from each other's point of view. But in situations where that doesn't happen, then mediation is advisable. This is, you have a neutral third party walks in and they hear both sides of the story and provide a bird's eye view of what they think is going on. They may even offer up solutions you didn't think about. But often, if negotiation fails, mediation might be the best thing to get a third party to come in and look this over as well. Arbitration is another one. This is a little bit more binding, whereas in negotiation and mediation, the parties are coming together and deciding a solution themselves. Arbitration, though, you are going before an arbitrator and you are presenting your evidence. You're presenting what you think the solution should be. You might have submissions of evidence, such as your contract being the biggest one here. You might even have witnesses come forward and tell the arbitrator what you think the solution should be. The other side will say their bit, and the arbitrator will provide a binding decision. Arbitration works similar to civil litigation in terms of, in principle, having a binding agreement, but it's a little less costly. Whereas litigation, this is the big one. This is court intervention. The relationship has likely thoroughly broken down. We have a material breach in the contract. Both sides are quite far apart in what they think the resolution should be. And now we need to go through active civil litigation to walk through submitting documents, meeting, negotiating, cross-examining witnesses, and then all before a judge having a final decision put forward. Litigation is usually the last stop and not something that we recommend jumping right into unless the situation calls for it. I mentioned when the situation calls for it. Well, as you've heard me say earlier, and I'll say it again now, every situation is different. The solution for one situation is not going to work for another. Negotiation might be the best way forward right away, but in some other instances, you might just want to jump straight into arbitration and not waste your time with negotiation, not even waste your time with mediation. How do we decide what's the best foot forward? Well, the first thing you do, obviously, is you assess the situation. How big is the breach is the first thing we would want to look at. How much money is at stake? How much of this relationship is at stake? Is this a minor breach, a material breach? Is it affecting other contracts that you're waiting on? For instance, if you're in construction and you're doing a major renovation project, if you're waiting to set up a drywall system, but the electrician that you subcontract is just not getting the wires in place, that breach is going to cause you to impact another breach. So you know how quickly you probably want a resolution. Speed of resolution is also very important. So understand what situation you're walking into. Do I need a fast solution? Is this not a big deal in terms of cost? Do I get along with the other person? Or are they starting the discussion very aggressively that I don't think negotiation is the right way to go? Let's go straight to arbitration. You'll know, sometimes with legal advice, what the best course of action is. And after you assess the situation, you should also consider choosing a cost-effective solution. So the order in which we listed before was in the most cost-effective way. Negotiation is the most cost-effective, followed by mediation, arbitration, and litigation. Before you choose an approach, decide what's the most cost-effective solution. Look at how much everything's going to cost and make a choice based on that. I mentioned before that timing matters and the circumstances of your business matter too. Negotiation is the cheapest option. But if you know the other side is just here to delay and you are in danger of losing significant clients, losing a significant business deal until this gets resolved, prolonged negotiation might not be the best course. You might want to just push it to arbitration and get an immediate decision that has a timeline of payment options, actions right away. One of the last things we'll recommend here is document everything. This is important for minimizing damage because your documents and your records of communication are the perfect witness to any sort of breach. The contract's important, email communication is important. If everything is verbal, then it relies on people's memory, and that's fallible. You can't really guarantee that someone's going to have the most accurate memory of what exactly occurred. Having everything written down cuts through that very quickly. You now know what the breach was because you know the contract. You know what the breach was because you have the email communications. You know what the breach was because you have your internal memos about it. You lay all that out, and then a lot of things that could be debated are now just clear. You save a lot of time, and that minimizes your also financial impact because you have everything there to point out where you were correct or the other party was wrong. A few key takeaways that I want you all to put into your hearts from this presentation is first, whenever you're drafting a contract, define clear terms. The meeting of the minds is critical for a contract. You can stop a lot of contract breach and litigation at the start by ensuring that everyone's on the same page. So when you draft a contract, and please put it in writing, use precise language. Make it clear what you're both agreeing to. No ambiguous terms. We recommend having a firm draft it for you so they can use that precise language, that up-to-date legal terminology, so that you are always protected by the most cutting-edge legal terminology and legislation in place. We also recommend you be proactive. If you're not keeping your finger to the pulse on your contracts, your breaches, the law, then you're always on the defensive. You're always on the back foot. You're always dealing with problems as they arise, rather than having everything at your fingertips as you move forward in business. If you're always reviewing your contract, or at least regularly reviewing your contract, and you are up to date, your lawyers keep you up to date on the law, keeping you up to date on what to be regular with, you're in communication with your clients, with your vendors, with your employees, and with your partners, then as problems arise, you see them coming and you can address them. And you're always in the driver's seat. Having a lawyer there with you to guide you in that approach is also very important so you can focus on your business. One other thing I'd like you to take away from this is know your options. There are many paths to a resolution if a breach occurs. It's not always litigation. Sometimes it's negotiation, a phone call, mediation, arbitration, and yes, litigation is still one of those options. But sometimes it's a good idea to even draft into your contract what those resolution options can be, and having a lawyer do that for you to let you know how to put that in properly will also be very beneficial for you as well. So that if a mistake occurs, you know how to fix it and you're not confused by what to do with this relationship that might be breaking down, especially when the goal of entering this contract and this relationship was to succeed and for both parties to come away happy. Now that we've covered everything you need to know about contracts, giving you a 30,000 view look of what the breaches look like, what the solutions look like, and what your options are, let's turn things over to the chat. See if we have any questions coming our way. I'm a contractor working on a home. I have a deadline to reach by the end of the month, but in order for me to do my project, I need to make sure that my subcontractor finishes tiling. I can't do the rest of the work without this. However, this subcontractor is taking way too long to finish it. I'm worried that he'll finish it, giving me only a little bit of time to complete what I need to do afterwards, thereby putting me to breach. What can I do? Excellent question. With a scenario like that, it's important when you're drafting your deadlines to be mindful of all the deadlines and also be mindful of how long it takes you to do work. Especially if you are a contractor in the scenario and you're waiting for work to be finished so you can begin the next task, you want to give yourself enough of a buffer to tell the other side to finish by a certain time so you have enough time from that date to finish yours. You also want to make sure your deadlines are considered when a breach occurs that's outside of your control. So if your subcontractor is delayed, you want to make sure that you have a buffer with your main contractor, with your client, to give you that leeway to fix that breach so that you're not guilty of another breach. If that can't be avoided, a lawyer can help you. If you are held in contempt or if you're held as a material breach, there are ways to hold the original breacher responsible for that mistake, but a way to avoid it is to have clear deadlines and solutions those deadlines be breached. What is a statement draft and how long does the process take? So a statement draft or a statement of claim, this enacts primary litigation. So this is a statement draft is essentially you telling the court to tell the judicial system, I have been wronged by this defendant. This is how much damage and harm I've experienced. This is why they're responsible for it. And this is how much it's going to take to make me whole again. That's what a statement of claim is. It's a formal declaration to the court of how you've been wronged and why the other person's at fault. How long does this process take? Great question. It depends. Every situation is different. Claims that are for hundreds of thousands of dollars can sometimes take less time than claims for tens of thousands of dollars. Claims that can be very complicated on the face of it can actually be done very quickly or sometimes take much longer. Whenever you come forward with an issue towards your lawyer, tell them what the circumstances is, and they can kind of give you a ballpark of how long it will take you to draft the claim and what the next steps will take. But every situation is different, so we can't guarantee exactly when it'll be resolved. Next question here, does every material breach automatically result in a contract being terminated? No. Technically, if there's a material breach in the contract, technically the contract's then breached. However, contracts and solutions are fluid. If you have a material breach in the contract, you can find some way forward to actually resolve it without acknowledging this is a material breach. So if you have a material breach in the contract, the parties to the contract can work towards a solution. So if they decide that the contract hasn't been breached, and they can find a solution forward. That's why negotiation, open communication is fantastic. That's why having it in the contract, how to deal with breaches or how to deal with problems is very important, so that you can keep doing business together just because it's a breach. What I will say, though, is that the other party, the aggrieved party, often has the right to decide that a material breach is a breach, even if the offending party doesn't think it's a material breach or thinks the other side's overreacting. Now you get into disagreements and potential litigation. One thing that happens in contract breaches sometimes is, well, actually quite often, is the parties disagree the contract has been breached to begin with. Even a material breach, as I mentioned before, should be quite obvious that it occurred. But the parties can sometimes completely disagree if a breach occurred or not, and that might be an open question for a judge to decide based on the preponderance and the factual nexus of the facts to decide, did a material breach occur and who's the offending party. So be mindful, and that's why precise terms are so important. You want it clear to everybody when a breach occurs so that if it does occur, there's no question that it occurred. If there's ambiguous language or something left in the air, sometimes a material breach can occur, but only one party thinks so. Really, when it comes, I think a really important point to really drive home here, for contract breaches, the most important thing here for every contract breach is what occurs before the breach occurs, at the drafting of the contract, at the meeting of the minds, for clear, unambiguous terms, so that everyone knows what the contract is going to deal with and goes forward. Thank you for the question. One more. What is your opinion on frustration of contract? I'm against them. No, it's frustration of contract is it's actually a very good solution. Frustration of contract occurs when, let's say in the employment context, when you hire someone to do a job, but for something outside of your control, you can't, the contract can't be performed anymore. Frustration of contract in theory and in principle says that the contract has been broken, there's been a breach, but no one's at fault. It's some outside third party that's responsible. So in theory, I don't like it when frustration of contract occurs, but in principle, it's an amicable solution to say no one's at fault, no one should be punished, but this contract doesn't work anymore. If you think that you've got frustration of contract, that is a question of law that's going to be turned on the facts of the case. So speak to a lawyer if you think frustration of contract occurs, because if you allege frustration of contract and the evidence doesn't support you, you could be in trouble. Thank you all for joining us today. Please feel free to contact us. If you have any questions, any specific things, any specific situations that have come up that you need our assistance with, or you just want to get some advice or some expertise turning to it, that's our contact information. We are always happy to assist. Have a wonderful afternoon and enjoy the rest of your week.